try to get these started on time because I know everyone's time is valuable. And hopefully we can get some good information to you folks, and then we'll allow additional people that are not here yet to trickle in. And there's a few minutes of housekeeping, so they hopefully won't miss anything too important. So I want to start by saying thank you to everybody that made the time to be here tonight to join us for the webinar. My name is George Padgitt of Sever Walker Padgitt, and we've invited you all here to talk about the Mississippi Crossing Project, really about pipelines in general, what landowners who are in the path of these types of projects can expect, what you should be aware of, ways that you can be more prepared to deal with these kinds of situations, a lot of that good stuff. We'll also spend some time talking about, how a firm like ours, what we do, how we might be able to help landowners past just this informational stage here at the beginning. And then, we'll make ourselves available as time goes on, either in the future, or after, in the coming days, for people to chat with in a more one-on-one setting, if that is something that makes sense, or if there are additional questions that folks have. We do have a chat, sort of Q&A chat function. I think Q&A is usually the best way to do that. So while I'm going through my presentation, if folks have specific questions that they'd like to ask, feel free to throw those in there. I should get a notification pretty much no matter how you do it, but try to do, I think, like I said, Q&A is typically what works best for me. If it's something that I can answer and will be valuable for the group, for everyone, then I'll try to answer that. If it's something that might be a little bit more individual or something that I don't want to spend my time tonight with, I'll just let you know. And then that's something that we can circle back to, like I said, again, in more one-on-one setting. So what I'm going to do is I'm going to share my screen so that we have this essentially PowerPoint that I've put together, and we'll go through that. I try to move fairly quickly and not waste folks' time. So bear with me here while I get that pulled up, and then we will go from there. Well, I apologize. I've having trouble getting my screen shared here, so bear with me just for another minute here while I make sure I get this figured out. I think I'm getting where I need to be. Yeah, well, maybe I'm not. I'm going to do my best here. It's just words on a screen anyway, so we'll just start working through the information, and then you guys uh, will still get the same benefit out of this one way or the other. So I apologize about that. But here we go. So what are we doing here? The main reason that we've invited you is we've learned over time as attorneys who work with landowners that are affected by eminent domain that folks don't always have information when they're in these kind of situations. I think on average, anyone affected by eminent domain is likely to only be affected by eminent domain once. So there's not going to be a lot of experience amongst folks who encounter these kinds of situations, and there's not going to be a lot of baseline knowledge for what to expect, what their rights are, what they can and can't do, what they should and shouldn't do, maybe more importantly. So it's really an opportunity for us to get information in front of people. And then as we're doing that, hopefully that will start to build relationships that will allow us to potentially work with some of you folks. Because at the same time as we do want to genuinely get information out there and help folks, we don't ever want to hide the ball. We're running a business. We do want clients. So, it serves a purpose where if nothing else, we're getting you really hopefully helpful information. And if you work with us, wonderful. If you don't, at least you'll be in a better spot than you were before you came to our meeting. So that's really the focus. We are a small law firm. We've got only a handful of attorneys, about 4 attorneys. We only do eminent domain and we only do it for landowners. So this is our specialty. We're a fairly niche practice, and we've probably done, hundreds, if not thousands, of these type of cases or type of takings. So we've got a lot of experience here, and hopefully can be a really good resource for folks. Um, this is a pipeline project, so there are kind of a few big things that we are going to talk about when we talk about pipelines. And so the first is going to be, can you fight it, or can you stop it, probably more appropriately. So we'll spend a little bit of time talking about that. We'll talk about eminent domain as a possibility. I know that's a scary term for a lot of folks, but it's not necessarily something that you need to be too worried about. It's a process. It's a legal process that's put in place and has existed for a long time, to hopefully provide a fair enough venue for there to be a determination of what your property is worth if it comes to that. But with pipelines, that's not always even something that has to be part of the process. So we will talk about it. And then we'll also talk a little bit about how pipelines might affect property, some of the big picture things that you guys should be keeping in mind and not losing track of, hopefully throughout the process, so that, even if you're having someone like me assess your situation and give you an idea of where you're at and whether you're in a good or a bad situation, and your offer that you might receive is good or bad, you can kind of have some of your own thoughts and be prepared to start assessing some of those things early on, and have the ability to make, some decisions for yourself about what might be best case scenario for you, whether you want to, how you want to handle things and how you want to progress through the process. So, um, there are really, I think one quick step back before we take a step forward. When we talk about how we can help, um, it does obviously go past information. That's the purpose of tonight. But as this process plays out, as there becomes more as the pipeline becomes closer and closer to completion, or to being put into the ground, there's going to be a timeline of events that folks that have property in the path are going to go through. And obviously, being attorneys that work in this field, one of the big things that we do is help people through that process, right? And so there's really 2 big components here. And we'll talk about each of them a little bit more, but the first is compensation, right? Nobody's going to allow somebody to take their land for free, which, nobody should, frankly, allow someone to take their land for free. The other side of it, though, is there's also a contract that you will either sign or will be forced upon you, potentially, in the worst case scenario, when this is all said and done. There will be an agreement between you and the pipeline company as it relates to your land and how it will be used, and who has which rights, and who, controls the property in which ways. and all of those things. So you really want to make sure as you go through this process that you keep an eye on both parts of that. Uh, I will admit, when I was a much younger attorney, money was really the focus for me. It felt like the important part of this. But the longer that we've been doing this, we've really learned and kind of fine-tuned the way that we negotiate the easement and really realized that that's maybe at least equal, if not more important. Because when, the money will come and go, but a lot of folks keep land in their family for generations, and those generations will be potentially dealing with this, as time goes on. And so, making sure that you sign the best possible agreement, as well as get paid fairly, they're both equally important. So keep in mind, there's those two major components to the process. So you know that's a big thing that I wanted to make sure that we didn't miss. So um, the project, we're not really experts on any given project. Our goal is not to educate you on exactly what's going to happen with this particular pipeline project compared to others, or be able to answer questions necessarily about where the exact route will go or any of that. We are experts on eminent domain and the process and the things that landowners face when they are met with this coming through their property. So I can share a little bit of information about the project, which I will do, but that's not where I'm going to be the most useful to you, is just the honest truth. But what I can tell you is, this is still in the fairly early stages. They have started the process of pre-filing with FERC. FERC is the Federal Energy Regulatory Commission, which is a governing body that regulates these types of projects. So they've started the process with FERC, but with them only being in the pre-filing phase, this is not something that is going to be reaching a culmination in the next 6 months or a year. There is a timeline here of probably a couple years, would be my guess. I mean, their estimates have them operational in 2028. So it's not something that's going to happen overnight, but we're always in a better spot when we're prepared before we start to face these things. So that's kind of part of the reason why we're reaching out now. It's better to be early than late type of attitude. This process, or this project specifically, it's about 200 miles, kind of crosses the entire state. Um, so it's a big project, 36 to 42-inch natural gas pipeline. That's about as big as it gets. This is a serious pipeline. And when you're talking about pipelines of that size, the easements are probably going to be fairly large and therefore fairly impactful. So this is the kind of project where there's a lot of um, potential room for them to sell you short, in terms of what they offer you, and a lot of room for them to uh, pretend that this is not going to be a big deal. But the reality is it is almost certainly going to be a very big deal, given the size and nature of the pipeline. So I promised we would talk about, can you fight it? Can you stop it more appropriately? I don't want to spend too much time here because this isn't necessarily our area of expertise, nor is it necessarily the area where we would suggest you spend most of your time. Now, with that being said, we have a very healthy respect for there is almost always a fairly organized opposition to projects like this. And in no way whatsoever are we saying, do not oppose it, do not fight it. What we're saying is we've seen many groups fight, and we've seen many groups fight unsuccessfully. And that is not where we have created our space in this world, right? We are attorneys that work with landowners that want to make sure that they're going to be prepared and or taken care of in sort of any eventuality, even the worst case eventuality that opposition to the project goes nowhere and the project is in the ground in a few years. And so while we acknowledge that that is, for lots of folks, a big part of this, it's just not where we're typically involved or where we're typically investing our time. But again, none of that is to say that that won't be successful. It's just really a difficult battle. It's a really resource intensive battle against companies that have almost unlimited resources. And overcoming the amount of investment that they can make in this with your own information and your own investments and experts, it's just an extremely difficult path to take. So for those of you that have that, in your sights, go forth. We certainly are not harboring any hope for that to be unsuccessful, frankly. If this project is one that doesn't go through, there will be other projects for us to work on. And frankly, we try to be as landowner friendly as we possibly can be. So if that means that certain projects fall by the wayside due to organized and successful opposition, then that's great as far as we're concerned. But we'll spend most of our time talking about what happens, past that or parallel to that in many cases, focusing more on just making sure that as the process plays out, you've got, you're putting yourself in a position where you won't be fight until the end when you finally potentially lose that fight. And then you're left going, what do I do now? They've got everything they need. And then they try to, run you over. We want to avoid folks ending up in that situation. So if you're not focused there, you're going to be focused on what can I do to make the best out of this bad situation, or what can I do to make sure that I'm compensated fairly, treated fairly, and get a fair shake in this whole thing. So to start that conversation, let's start talking about eminent domain. Eminent domain in general is this idea that the government can take private property from citizens if they pay just compensation, which is supposed to mean putting you effectively in the same position using money as you would have been before. So if you had a piece of property that's worth $500,000, they come in to put this pipeline on, and now your property after that is only going to be worth $300,000, then just compensation would be $200,000. And we'll talk more about this, but the reality is that's always a moving target. We can't, property valuation is not an exact science. So there is some art to it. We try to be quality artists when it comes to that. But there's a just compensation requirement that might mean something different to you than it does to them, which is why there's jobs for folks like me, because we've got to make sure that we either find a way to bridge that gap or to zealously advocate for people in hopes that we can get that amount that those people feel would be just. So the other side of that is that if they're going to take your property, it needs to be for a public purpose. Now, when it comes to things like pipelines, especially natural gas pipelines, there's effectively just been years and decades of courts and sort of the way that we've fundamentally designed our energy infrastructure that have created a situation where these are often considered a public use. It's another difficult battle to fight to argue that a project like this doesn't serve the public good, which is effectively the standard. I apologize. I've got kids, and if anyone who's got kids knows you're always battling some sickness that they're bringing home from school. So, eminent domain is in the Constitution. It's in the Fifth Amendment of the Constitution. So if you guys are looking for somewhere to sort of find the foundation of where this comes from, that's where I would point you. It is essentially in every state constitution as well in some form or another. And again, it is an idea, but there's a process that then comes along with that. And you might hear these terms used interchangeably, but they are a little bit different. Condemnation or a taking or an appropriation. Those are some of the words that you might hear used for the actual process. But those are really just the ways in which we effectuate their power of eminent domain. So remember, they can take private property for public purpose, even when it's a private utility company, because they'll be granted effectively quasi-governmental status for this specific purpose. But you're entitled to just compensation, and it's your job / our job for folks that work with people like us to determine what that is, aggressively advocate for it and make sure that we end up in a spot where everybody, feels like they got a fair enough shake here. So when we're talking about what that process looks like, I'll give you kind of a brief, we don't want to it's a cart before the horse a little bit because we're still in the pretty early stages, but I'll give you a brief kind of layout of what that usually looks like. So they have all these regulatory hurdles that they've got to climb or jump over before they can come to you and say, we're taking your property through eminent domain. That's with the FERC filings and things that they're doing. That's the process that they're in right now. Eventually, if they have not already, and forgive me if I'm not 100% correct here, but I do believe that for the most part, folks don't have offers here. If I'm wrong about that, I'm sure some folks will let me know, and that's something that might change a little bit of what I'm about to say, but not really. Effectively, eventually you will get to that point though. And then once you get to the point where they're making you an offer, then there's an opportunity for you and them to try to come together on some kind of agreement for them to essentially voluntarily acquire your land, although it won't be voluntary, right? Because there's always this threat of eminent domain. Um, but so let's say you don't reach an agreement during that period, then there's a legal process that they can enter into where they would effectively sue you to gain access to your property to build their project. Now, once you get into that legal part of the process, you know, that's where you really should have somebody, whether it's us or somebody else. That's really where it becomes important. It is going to be incredibly difficult for any landowner to navigate that on their own. But that's also way down the line. And frankly, one of the nice things about pipelines is that often it's not even fully necessary. Um, you know, there may be an opportunity, and there typically is with pipelines, to find the place in the negotiation, you know, effectively a sweet spot where you can be paid in a way that you're okay with, you know, and reach a deal short of condemnation. But just so you're aware, that's typically those are the steps. They've got regulatory stuff. They start making offers to landowners. They negotiate with landowners. The landowners that they can't get deals with, they sue. So that's how that will play out. I do have one question, so I want to get to that really quickly. It basically says, will they take outright ownership of your land? Is it a lease? You know, how does this work? Which is a good question. So when we're talking about pipelines, what they will take is called an easement. And what that means is that they will not take outright ownership of your land. So if you had 20-acre parcel before they came, you will have a 20-acre parcel after they come. But what you will have is an easement on your property. And so that easement, the size of that will vary depending on what they need from you. But basically, what that footprint with the easement, uh, you will lose certain rights to your property. So while you'll still own it, you will effectively be giving them control over that process or over that portion of your property. And what that looks like again will depend on what you negotiate in your easement agreement. But they will have the right to do what they need to do, and you will have the right to effectively still use that property in any way that doesn't interfere with that. Now, I wish I could tell you that that was going to be a lot of ways, but the truth is that, you know, often you could still farm it. But past that, there's going to be very few things that you'll be able to do with the ground, which is why, even if they're not taking it outright, there's still going to be some, you know, pretty important elements to that agreement so that you can hopefully maintain as much control over the property as you can, while also hopefully getting paid as much as possible because you're going to lose most of your control over that ground. So again, that's called an easement. It's a little bit different than them buying it outright, but it will still result in, you know, you effectively not having control of that. I just got another question about what's our fee percentage, which is getting a little bit ahead of me, but I'll answer it because why not? We'll talk about it a little bit more later. But basically, we get paid based on contingency fee arrangement. So we're not hourly attorneys. We don't require uh, retainers and monthly billing. We get paid based on the type of value that we're able to provide to you. So let's say they come to you, offer you $100,000 for your easement. We come in at that point, we negotiate an extra $30,000. We typically take 33% of the value that we add. So we would, in that case, take $10,000, 33% of the additional $30,000 that we negotiated. That's generally the best way for eminent domain attorneys to function. If everybody had to pay us up front, and as the process went on, a lot of people wouldn't be able to be represented. So it allows us to represent folks that we wouldn't otherwise. It also gets us in the same team, the same mindset. It works well for eminent domain because we're not necessarily trying to work to work. We're trying to work in an effective and efficient manner for you so that we maximize what you receive, you know, and really align our interests. So typically that's how that works with in terms of got another couple. Um, should we have received notice about what part of our property is affected? I don't want to scare anybody. If you haven't heard a ton yet, that doesn't necessarily mean that there's something wrong. When they're in these early stages, that information is typically publicly available, but it's really on a publicly available in the sense that if you know exactly how to find it and you know exactly what you're looking for, you might be able to get that answer. But eventually, you will get those answers. It will get to a point where you will be told those kinds of things as it's just a necessity. They're going to have to eventually come to you and say, this is where we need to be. This is what we think it's worth. So that'll come. And early on in the process, there might even be opportunities for you to negotiate with them about, well, I don't want it here. It'd be much better if it's over here, kind of thing. No promises there because they don't always work with you, but they might. Another question, does it impact mineral rights? Almost never. If they're asking for your mineral rights, something very strange is happening. So it should not affect your mineral rights in any way. If that's something that they're trying to effectuate, be very skeptical of that. That would be my advice. So, all right. I just had another question come in, but I'm going to come back to that in a minute. I've only got a couple more slides and I really want to get through that portion of what I've got so that the folks that don't have additional questions or might want to get back to their night can do so. So the I talked a little bit about what the process might look like. Let's talk a little bit about pipelines in general and how they affect ground. I'm not going to try to give you a super long lecture, but let's hit on some big stuff. So there's two parts of the value to something like this. One is, what's the value of the land that they're physically encumbering? They need 4 acres for their easement. What's the value of that 4 acres? Um, they might because it's an easement and not an outright purchase, they might try to argue that they're only entitled or they're only required to pay you less than 100% of that value. They might try to pay you as little as 50%. I've seen lots of crazy stuff, but they should at least be paying for the land that they're encumbering. What they should also be paying for is, how does this impact your parcel, right? So there will be folks who have a very small corner part of their property getting nipped. That may not have a big impact on the rest of the value of their parcel as a whole. That might not create many problems for them in terms of how they use their property. But a lot of people will have very different situations where they're either coming straight through the middle or on a diagonal. They're going to create all kinds of problems. So those problems can range from things like farming inefficiencies, crop loss, that's for really agriculturally oriented properties. If we're talking about properties that have, potential development uses, there can really restrict your potential development opportunities with these kinds of pipeline easements, which can be a big deal. If you got a home on the property, no one wants to live, within a couple 100 feet of a high pressure natural gas pipeline that could be dangerous to them. So you can talk about home valuation, but in the big picture, the really big thing for impacts is stigma. And I know that might sound oversimplified, but it's almost intended to be, because it really doesn't matter why people believe this, but it's pretty clear based on years and years of evidence that unless you're in a market where land is so hard to come by, or where people will just buy anything that's out there no matter how bad it is, people are going to prefer a piece of property that doesn't have a pipeline to one that does. So once your property has a high pressure natural gas pipeline on it, it is now, at least theoretically and in many ways practically, inferior to the neighbor's property that doesn't have it. And as a result of that, you're likely to see at least some reduction in value to your property. So the easiest way to explain that is just stigma. Some people, because it's dangerous. Some people think this isn't the case here, but some people, are worried about health effects when it comes to like power lines. They use easements too. So it doesn't matter if it's those things. It doesn't matter if it's truly farming inefficiencies. It doesn't matter if it's, whatever. But the reality is there probably will be some impact. So we try to estimate that. We try to measure it to the best of our ability and also have you recover something for that. So that's kind of the big picture of how we look at the potential impacts of pipelines. It's really a case by case basis. Every piece of land is different. It will cross every piece of land differently. It will be a quarter mile from some people's homes, and it will be 100 feet from other people's homes. And so all those things matter in terms of how you value this and what type of impacts you're going to see. So um, that's going to mostly wrap up what I have prepared. We try to keep these to about a half hour and encourage people to reach out to us after. I still have a couple questions I'm going to answer. Normally, I'm able to show you this. Again, I apologize for the screen sharing issues I'm having, but we do encourage people to reach out to us. I want to give you guys my phone number. So for anybody that wants to write this down, I'll give you a little bit of a heads up here so you can grab something. So that, feel free to give me a call. I'm happy to talk to anyone. If anyone does have an offer or is anticipating getting one, we review offers for free 100% of the time. That's a big part of what we do. We want to vet the case the same way you want to vet us. So we'll take a look at everything. We'll give you an idea of what they might be missing on, I try not to give anyone like this is what it should be numbers, but I can definitely tell folks whether it should be, you know, the 10K more or 100K more kind of thing. And so we can already start some of those conversations. Even if you don't have offers, I can answer additional questions in a more one-on-one basis. So my phone number is 614-360-2818. So I'll read that again, 614-360-2818. You can also call our number that's on our website, and you can ask for me or anyone else in the firm, frankly, and you'll get the same type of good information. And if you want to email me, my email is George, which is George, like you would expect it to be spelled, or like I typically see it spelled, at S as in Sam, W, P as in Paul, so like Sever Walker Padgitt, SWP dash legal.com. So SWP dash legal, legal.com. So feel free to reach out to me either one of those ways. If you have additional questions or just want to chat, we'd be happy to spend time with anybody. And like I said, as the process progresses, we'll be available for anything that you guys need. So for anyone that doesn't want to stick around to hear me answer these other questions or who may not have questions of their own, feel free to go. We definitely appreciate you all coming here tonight. But I'll get to answer these questions, and then as it becomes clear that there's no more, then I'll wrap this up and allow everybody to get back to their lives. So I had a couple questions from one person. If we intend to sell the property before the project is finalized and the sale is unrelated to the development, what is our legal obligation for disclosure? That's a really fair question. That's a little bit of a gray area is probably the truth. I mean, I'm not going to be your best resource for that. Some type of real estate professional is probably going to be a little bit better equipped to answer that specific question. But I can tell you what I believe to be true, which is you probably should disclose something like this. Uh, and that becomes even truer the further the process plays out. As we sit here right now, and you don't have an offer, you don't know what's going to happen. I don't think you got the same type of disclosure requirements as you would have otherwise. I still think the safest thing for you to do probably is to disclose. But I think, you get to the point where you've got a concrete offer in hand and whatever, I think you're probably going to end up in a position where you probably should disclose that. But I would recommend you consult with someone who's like a real estate professional. I mean, there are disclosure rules and they'll probably be a lot more tuned into what those look like. I'm reading this next part. Okay, so it kind of asks if the pipeline goes through the property in a way that it kind of creates what we call residue parcels, where there's one side that might be smaller, and in this case, it looks like maybe bordered on the other side by a railroad. Um, how is access across the pipeline typically managed? 99% of pipelines that get built today are underground. I would be shocked beyond belief if this pipeline or any other pipeline that I was involved with were not underground. So I think you can count on it being underground, which means that as the project is completed and in the ground, access is really not a concern unless you need access for extremely heavy machinery or something along those lines. Excuse me. Um, while it's being built, there are almost always ways, again, unless your access needs are really extraordinary, for them to maintain some type of access for you. So I wouldn't worry too much about that, but it's kind of a good example of things that you want to make sure you are bringing up and addressing with them in negotiation. You want to you want to make sure you get those things out there. You say, hey, we've got access concerns. We want to know how you're going to do X, Y, and Z. And frankly, that might involve how they're going to access their easement on your property. So a little bit of a different sense of access, but you want to have those conversations. You want to make sure that you're all on the same page. If they were to make it inaccessible, they would owe you for it. They would have to pay you for that. That's about as clear cut as it gets. But they're probably not going to make a portion of your property inaccessible. We rarely see that with pipelines. It would be a pretty extreme situation. So I don't know if I'd be worried about it, but I think, be prepared to have that on your radar. Make sure you're understanding what's happening when you're finally getting information, better information from them about what they're planning to do. And if that's something you need to address, you can address it. That seems to me like something that if you've got real concerns or potential issues, that's the kind of thing that you can usually work out. So hopefully that's a good answer there. I don't think that's something you need to be too terribly worried about, but it's good to be aware of those kind of things and making sure that you're on top of it from day one. That'll be your best bet for making sure that you don't end up in a bad situation with something like that. Excuse me. So, got a question about timber. So, sorry, folks. So we treat timber a lot like a crop. So it's not corn, obviously, but it gets treated similarly. But you're typically not going to get paid for, you could have harvested it again in 20 years. What you will get paid for potentially is just the harvest, the one harvest that you don't get to undertake now, because it won't be like corn in the sense that you won't have the opportunity to simply regrow it. They won't allow you to put trees back on the easement. But we try to value it in the best way that we possibly can. But you're rarely going to end up in a situation where you're getting like value for harvest 20 and 40 and 60 years down the road, because it's just a little bit too speculative, is the truth. But if they'll pay us for it, we'll allow them to. Like we'll ask, if that makes sense. We will argue for it and then allow them to tell us no, kind of thing. So, what happens if the pipeline goes through the middle of 40 acres? I think I've talked a little bit about that, but the big thing to remember there is that there's just going to be damage associated with that. That's going to affect the value of the parcel as a whole. It's going to make your property less desirable to a buyer, plain and simple. There may not be anything you can do about it, is the truth. I wish that I could say something different there, but I said earlier, you may be able to negotiate route, but you also may not. That is really something where you're largely at their mercy. So, if that is the case, then you've got to be a little bit more aggressive about how you deal with it than someone who, again, like the example I used earlier, it clips a corner and isn't going to be particularly impactful. So, just keep all that in mind. That's a big part of what we do. If you've got a parcel where they're coming right through the middle, you're going to be in a more a potentially where a situation where an attorney would be potentially more beneficial for you, because there's more to lose, is one way to look at it, or more to gain from working with an attorney, making sure that you're compensated fairly. I also see here 33% of the offer is our fee. That's not correct. So like I was trying to explain earlier, and hopefully I did an okay job, but maybe I need to clarify. We take 33% of the value that we add to your original offer. So if you come to me with your offer, that's yours no matter what. The way the fee's intended to work is that if we do a great job, we'll get paid well, but that'll be reflective of you also receiving significant additional compensation. And if the case is either not destined to be good, or for one reason or another it doesn't work out the way that we would want it to, and that's most likely to happen at like a trial setting. Somehow it goes all the way to trial and you don't get a good verdict. We would then basically not get paid. We only get paid 33% of the value we add. So if we don't add much value through any number of different scenarios, then we don't get paid, or we get paid very little. But if we do a great job for you, we get paid well. Like I said, lines interests, you know, it would be very difficult. I'd have trouble I mean, as an attorney myself, I'd have trouble just paying an attorney to do something for me for very long. It's not the cheapest thing to do to hire an attorney. So 33% of value added over and above whatever offer you come to us with. That's how fee is intended to work. And then I see one more question. If a landowner is growing timber, can you get compensated for the revenue loss? So that's a lot like the other question. Like I said, it's difficult to like capitalize that type of income stream because it's fairly speculative and very long term. But that is not to say that you do not get compensated for timber. You absolutely do. So, you know, that might be a challenge here. If there's a lot of timber land, we might have to come up with a plan with our landowners, may potentially bring in some experts. Experts are usually pretty important in our work, and come up with a way that we're going to value this that we feel like fairly compensates our landowners. So that'll just be a challenge for us, it sounds like, and one that we have worked with and overcome in the past. I have no reason to believe we wouldn't be able to do the same here. So if timber is a concern, you're going to get paid for it. It's just that it might get a little tricky. There might be some negotiation around how we actually arrive at the number, to be fair. So I think that pretty much answers all the questions that I've got. Like I said, I really appreciate everybody coming. Please feel free to give me a call, send me an email, and we can chat again in the future. If you've got more questions or just want to bounce some stuff off me, whatever that looks like. That's what we're here for, and we'd love to work with folks. We've got a lot of experience on projects like this and think we bring a lot to the table, and are great assets for our clients. So really appreciate it. If anybody needs anything, let us know. But thank you. Good night. I'm going to end that here. So.